Today is July 27th, 2022. Today I will be interviewing retired Chief Justice Lawton Nuss of the Kansas Supreme Court in a location he's quite familiar with. We are now in the Supreme Court conference room located on the third floor of the Kansas Judicial Center in Topeka. We are directly south of the Capitol building. My name is Richard Ross. I serve the state of Kansas, the Supreme Court, and the Court of Appeals as reporter of decisions for 38 years. And during 16 of those years, my last 16, I had the great pleasure to work under Chief Justice Nuss. We are also welcoming today David Heineman. He is the videographer, former President Pro Tem of the Kansas House of Representatives. This interview is part of the Kansas Oral History Project collection known as the Kansas Courts and the Rule of Law. This series of interviews examines the Kansas judicial branch and how the courts interact with the other two branches of government, the legislative and the executive. The Kansas Oral History Project is a not-for-profit corporation created to collect oral histories from Kansans who were involved in shaping and interpreting Kansas public policy. Funding for the project is provided by individuals and volunteers, as well as prominently by Humanities Kansas, a nonprofit cultural organization. Recordings and transcripts of these oral histories are available to researchers, educators, and the general public, and you can view them at the Kansas Historical Society, the State Library of Kansas, and also online at ksoralhistory.org. And now we'll proceed with our interview. Chief Justice Nuss grew up in Salina, Kansas, and he attended the University of Kansas on a full-ride Navy ROTC scholarship. He graduated in 1975 with a BA in English and in history. Following graduation, he served 4 years in the United States Marine Corps, where he attained the rank of captain. And following that, he entered KU Law School, where he got his Juris Doctorate degree from KU in 1982. For the next 20 years, he was a trial attorney for a prominent law firm in Salina, Kansas, before being appointed as a justice on the Kansas Supreme Court in 2002. 8 years later, he became Chief Justice, and he served with distinction until he retired in December 2019. Welcome, Chief Justice Nuss. It's my pleasure to interview you today. And if you will indulge me a little, I will refer to you throughout as Chief, which is the term I've used ever since you were Chief Justice.
Thank you, Richard. It's my pleasure to be here.
Great. We've got a lot of territory to cover today in a short amount of time, but I gave a brief bio of you. Is there anything you'd like to add to that?
I think that's a good summary.
Okay.
And I think we can proceed to the heart of the interview if that's your preference.
That's great. Thank you. Chief, what motivated you to leave private practice and change your legal path to pursue appellate work?
Well, I had applied in 1995 to be on the Kansas Court of Appeals, and I think that's because I got a taste of being a judge or making judicial decisions when I was in the Marine Corps. I sat on a special court-martial board. I also served as an officer when our commanding officer was absent to handle what they called NJP, or non-judicial punishment. Very low-level offenses. I would bring the Marine in who allegedly had committed the offense. I heard his story. I listened to witnesses, collected all the facts, and then I pronounced judgment whether he was guilty or not guilty, and then I imposed a sentence. I think I did that when we were in the Philippines. And I just enjoyed those experiences, hearing evidence, thinking things over, reaching conclusions, and then making a decision and carrying it out. And that was one of the reasons why I applied for the Court of Appeals in 1995 and why I pursued appellate work even after that.
What was the process that you went through to be appointed to the Kansas Supreme Court by Governor Graves?
Well, as I said, I had applied twice in 1995 for the Kansas Court of Appeals. I was not selected for the panel of 3 whose names would be submitted to Governor Graves by the nominating commission. And as you probably know, that commission is 9 people. 4 of them are appointed by the governor, and 4 of them are elected by the lawyers in each congressional district. And then the chairperson is elected by lawyers statewide. They take the applications from people, and then they do interviews, they check references, and they dig deeper than the references that you supply. As I said, they do the interview. The interview is open to the public. Their deliberations are now open to the public. They choose 3 names to go to the governor. The governor then interviews you, and then the governor makes a choice. One thing I would add is that that system has 2 very important features. Number one, anybody with a law degree in Kansas and who is at least 30 years old can apply. So when an opening occurs, about 11,000 notices are sent out to all the lawyers and judges saying, here's an opportunity for you. So it's equal opportunity. And then, of course, once you apply, you are in a competition with your fellow applicants to see who is going to be named to that panel of 3 and then ultimately chosen. I'd like to point out the example of Simone Biles. No one said, we now pronounce you the greatest female gymnast in the world. She had to prove it. She had to compete against her fellow Americans in the Olympic trials and the World Championships, and then also against all comers around the world. And impartial judges said time and time again, Simone Biles, you are the best. And so I like the fact that we have a competitive process in Kansas. It's not an election like we used to have before 1958. It's not a federal model where the governor just says, I'm going to choose this person to be on the court, and then you get Senate confirmation from the Kansas Senate, and then you are in. And that does not leave many other people in the state saying, well, wait a minute, I wanted a chance at this. And how do you know that person is the best candidate? You just happen to choose one person that you wanted. So I think those are real important features of our system, and I really embrace them.
Well, I went through or witnessed a lot of those proceedings over time, and I was always very proud of the fact that the 3 nominees were all highly qualified. So I knew it was a difficult decision by the governor to select from among the 3, but that just proved to me how our system worked well to choose the best. So.
To carry that point a little further, Richard, with an example, in around 1998, Governor Graves chose Carol Beyer to be on the Kansas Court of Appeals and rejected Lee Johnson for that position. In 2000, he appointed Lee Johnson to the Court of Appeals but rejected me. In 2002, he appointed me to the Kansas Supreme Court but rejected Judge Marla Lukert. And now, of course, Judge Marla Lukert is the Chief Justice of the Supreme Court because she was appointed directly after my appointment. So I think Governor Graves had a pretty good idea for qualified candidates.
Yeah, I would say so. I wish to focus this interview primarily on your tenure as the Chief Justice. But before we get there, can you describe what it was like to adapt to serving on the Supreme Court after 20 years of private practice, becoming a government employee as opposed to a private practitioner?
Yes, let me start to answer that by saying that is one of the points that I emphasized when I applied for the Supreme Court in 2002. In between, or before that, as I said, I'd applied twice for the Court of Appeals in '95, wasn't selected. In 2000, I applied for the Court of Appeals again. Lee Johnson was appointed instead of me. And then in 2002, I was waiting for the next Court of Appeals appointment because I thought it's not hard to move from private practice to the Court of Appeals because it's done pretty frequently. And then 3 judges in Salina approached me and said, there's an opening on the Supreme Court. You should apply for that. And I said, oh, that's for the really smart people. I've never even thought about that. And they said, we've seen you in our courtrooms. We've read your briefs, your motions for summary judgment. You can do this. So I thought, well, all right. But I'm going to be competing against people who are district court judges and Court of Appeals judges. And I said, I will turn what looks like a disadvantage of mine into an advantage. And I emphasized to the nominating commission that the last time someone had been elevated from the practice of law directly to the Supreme Court had been about 25 years earlier. That was an individual who also happened to be the minority leader of the Kansas Senate. So he had some political influence. But I thought, okay, if it's been 25 years since somebody moved in that direction, then I can say it's time for attorneys to have a voice on the Supreme Court, a fresh voice. And I looked at the people who were going to be my colleagues if I got appointed, and it had been about 15 years since any of them had ever tried a case to a jury. And I told the nominating commission, it was a month ago when I had my last case that I tried to a jury. So I bring that perspective. And I think that was part of the reason why the nominating commission selected me. And I think it was also part of the reason why Governor Graves appointed me, because it had been such a long time. And next, to answer your question directly, it was a challenge to move in from somebody who was arguing cases in front of a judge to now being one of the people who decided cases. And I remember very well my first couple of days on the court when we were having oral arguments. And I saw some attorneys on the other side of the lectern that I knew, and they were arguing cases. And I looked to my right down the bench, I saw my 6 colleagues, and I said, I can't believe they're paying me to do this. This is great. And another thing I would mention is the next youngest member on the court was 14 years older than I was.
Oh, wow.
We had 2 more people who were set to retire in 3 months because of age. And the next youngest was then Justice Robert Davis, who was, I think, 63 at the time. So I brought that perspective too, not only as someone who had come directly from the practice of law, but the age difference as well.
Yeah, very good.
But I had a lot of learning to do.
Yes, it did.
A lot of learning.
I know you mentioned Robert Davis. It was a very difficult time in this building and for the Supreme Court towards the end of his tenure as Chief Justice. And he had a terminal illness. I don't think we knew initially it was going to be terminal, but he was gone a lot because of treatments, and we didn't have Zoom back then, so he was unable to travel from where he lived outside of Topeka, and you had to step in because you were the next senior justice. Can you describe what it was like during that period of time to be acting as the chief but not really being the chief?
Yes. On Kansas Day 2010, after Bob Davis had been Chief Justice for about a year, he called all of his colleagues into this conference room and said, as some of you know, I've not been feeling real great for the last couple months. I just got a doctor's diagnosis. I have a form of blood cancer, and I'm going to have to be gone for a few months, and I may wind up getting a bone marrow transplant. But in the meantime, Lawton Nuss will take over. To make a real long story short for Bob, he never came back. He wound up in KU Med. I went to visit him there once. He was in quarantine, so he could try to get a bone marrow transplant. And then in August of 2010, he resigned or retired and then died the next day.
Yeah.
And during that time, we didn't know what his condition was, whether he would be coming back or not. So I was trying to run things but not make irrevocable decisions that he would not like when he came back. But I want to emphasize I had the full support of my colleagues. And so for about 7 months, we had 6 people, 6 justices doing the work of 7. And I kept my other duties as a regular justice, such as being a departmental justice for the first departmental, the number 1 department in Kansas, which is an area from Salina north to Nebraska and west to Colorado. I kept all my other liaison duties, and I was trying to be the head of the judicial branch of government. You may remember at that time the nation was suffering a recession. Funding was very hard to come by, and basically the legislature and Governor Parkinson at that time said, "I'm sorry, but we just don't have the money that we can give you, judicial branch." So I wound up closing the courts statewide for 4 days in the spring of 2010, the first time that had ever been done in the court's history, in the history of the state. And there were some tough times. In addition to closing courts, we were looking at underpaid employees, underpaid judges.
Now, this was the time when you were Chief Justice? Or
This is when I was acting.
Before you were still acting?
I was still acting. And as I said, my colleagues backed me all the way, and we decided that we would do something called a weighted caseload study. We wanted to see how much our judges were working and how much our employees were working, whether they were overworked or underworked, and then we would make adjustments by shifting them from place to place. And we also, during that time, a little later, a couple months, formed what we call the Blue Ribbon Commission. And that Blue Ribbon Commission was chaired by Court of Appeals Judge Pat McEnany. We had a real diverse group of people who were on the commission. And their charge from us was to look at the Kansas judicial branch and find out what we're doing right, what we're doing wrong, what improvements you could suggest. So about a year later, they gave us a report with over 70 recommendations.
Oh my.
And that, we called that Project Pegasus.
Yes.
And we also looked at that and then the weighted caseload study. And one of the things we found about judges was we did have enough judges in the state to handle all of the caseload, but they were not in the right places. Some places had an overabundance of judges and didn't have to put in a lot of time, and other places were really short of judges, and those judges were really getting overworked. We had the same issue with some employees. With employees, we could shift them around. But for judges, the legislature had passed a statute probably 40 or 50 years earlier that said there will be 1 judge per county in Kansas. And some of those counties, those judges did not have a lot of work because there wasn't a big population. And other places, some urban counties, they were shorthanded. They needed more judges, but we were not authorized as a Supreme Court to move them from the overserved area to the underserved. So that was a recommendation that we received from the Blue Ribbon Commission and that we asked the legislature to change, and ultimately the legislature said, no, we're not going to change that. Yeah. So I might also add, if I could, my colleague said there is something called the Conference of Chief Justices. It's the Chief Justices of the 50 state Supreme Courts and also the head appellate court for the Washington, D.C. It's not the federal court, but they have a state level court, and then our 5 territories. And every year that conference has a meeting, and my colleague said, we want you to go to that conference and learn what you can and bring back the good news. So there was a Chief Justice there that I had just seen in action, and I was real impressed with him. And I said, I'm really struggling here. I'm just filling in for our Chief Justice while he's gone. And I said, but I'm having a lot of trouble getting all my regular duties done, plus doing the Chief Justice's duties and writing my opinions that for the court. And he laughed. And he said when he became Chief Justice, he also had trouble getting his opinions done. So he went to his former Chief Justice, went to her house, and he said, "What am I doing wrong? I can't get this done." And she laughed and she said, "That's what nights and weekends are for, to get your opinions done, because as Chief Justice, you're spending a lot of your time on administrative matters." And I felt much better after I talked to him, and that turned out to be proven over the years. In talking with fellow Chief Justices from around the country, they would say, yeah, about 80% of our time is spent on administrative matters. And that when I was not a chief, but just a regular or an associate justice, I probably spent about 20% of my time on administrative matters. So that was a real challenge for me to embrace. And we did not get a replacement for Justice Davis until January. So for about a year, 12 months, my 5 colleagues and I were trying to run a Supreme Court that typically is run by 7 people.
And did you have some appointed judges that served during that time?
We did. One of the things I changed when I was chief was a practice by a prior Chief Justice or justices, I won't mention their names, but when there was a justice who needed to recuse on a case, this particular Chief Justice would choose the same 1 or 2 people over and over again. And I talked to my colleagues and I said, I don't agree with that. I want us to be able to appoint a variety of people. In particular, a district court judge, well, let's pick on somebody from Colby, who often wonders how the Supreme Court does things. And so I want to invite that district court judge to come sit with us on a case. So he or she can see how we do things. We can lift the veil of mystery, and then we can also get that judge's input on our cases, because a district judge sitting with us might say, well, you know, I'm looking at this case that was assigned to me, and I can see how a district court judge would do this because I've been tempted to do that myself, or I have done that myself. And so both sides
it provided additional information
exactly.
and perspective. Yeah.
Exactly. And so I asked my assistant to prepare a list of all the judges by seniority in Kansas. And I said, I want to do the chief judges first, but then I'm going to go strictly by seniority. So if a judge has been on the bench for 25 years and they're the most senior, I'm going to call them here on a case. And as you point out, we had, well, a year's worth of dockets that Chief Justice Davis was not there to sit on. And we didn't have his replacement assigned yet. So I had a lot of people that I needed to contact to come sit with us. But it turned out to be a win-win. And I had a lot of judges say, this was great.
I know it was a win-win. And I knew quite a few of those judges that you appointed. They would come to my office just to visit. And to a person, they were quite honored by that and really enjoyed the opportunity. They learned a lot, but it really gave them a boost in their morale that they were chosen for that particular litigation.
Well, and I might add, if I may, they then went back to their districts and they told their colleagues there the veil of mystery has been lifted, and those justices don't just sit around in their ivory tower ordering people to do a lot of things, and they don't flip a coin or roll the dice when they're in the conference room trying to make a decision. They're actually working hard. They're reading all the briefs. They have sometimes some very vigorous discussions about the case, and then they take a vote. And they say, so if you're complaining that the Supreme Court justices are lazy, that's not the case at all. They're very hardworking.
Well, I would agree with that part, because I
good.
worked with all of you. You pretty much answered what my next question was going to be, but maybe you can add a little bit to it. The Chief Justice, you indicated about 80% of that role is administrative. So on August 3rd, 2010, you became Chief Justice. And you are as the chief, you're the head of the judicial branch. You're the top person. So all the 1,500 or 2,000 employees, whatever it is, in the court system, you are in charge of them. what all duties did that involve? Or you don't have to tell me all the duties,
Right.
but
Well, I can.
generally.
Yes, I can tell you that the legislature has specified, or at least I guess I should say, has recognized several of the duties. They say that the Chief Justice shall be responsible for presenting the budget for the judicial branch to the legislature. The legislature has also specified the Chief Justice is the spokesperson for the entire judicial branch. And so if there's something going on in the judicial branch and one of the reporters has a question because it might impact on how the Supreme Court is doing things or how district courts are doing things overall, those reporters come to me and they want to ask me questions one-on-one, or they want me to conduct a press conference, and the TV stations are there, and then I explain what is going on. You also mentioned if there are justices who need to recuse on a case, then I was responsible for finding their replacement. And I would go down the list, and then we would call some judge in some other part of the state and invite them to come up with us. I also attended the annual conference of the Conference of Chief Justices, and they conferenced different places throughout every year. Came back with some good ideas. We tried to implement those if they were really good. If we decided, we as a court decided we needed to have something done, I would be responsible for appointing the committee and usually their members. For example, I appointed Judge McEnany from the Court of Appeals to chair this Blue Ribbon Commission. I helped my colleagues decide that yes, we need a weighted caseload study, and I would be checking the reports on that. We had a court budget advisory committee around 2014 or 2015 because we were facing an $8 million budgeting shortfall. So I appointed that chairperson and that committee. The same thing for a pretrial justice committee. I appointed that chairperson and then the committee members. Just a lot of things that I think most people don't normally see. I had meetings with my staff every morning. I met frequently with our judicial administrator. She was kind of the CEO for the judicial branch. I was instrumental in hiring her years ago. Also instrumental, actually, in hiring your successor on your recommendation. I hired people to be our liaison with the legislature. And every year I would go to legislative committees, the House Appropriations Committee, Senate Ways and Means Committee, and then I would present our budget and answer questions and try to extend the hand of friendship, if you will, to members of the executive branch and the legislative branch. I hosted lunches for those folks in this conference room. To my knowledge, that had never been done before, but we had the governor and lieutenant governor come speak, the Senate president, the Senate vice president, the leader of the House Democratic Party, et cetera, et cetera. And we had those probably 2 or 3 times over the course of my tenure. Governor Kelly was here, Governor Brownback was here. So we didn't play any favorites on political parties. We just wanted to get to know them better and know that we're, all Kansans and we're trying to do the right thing. So that's just a sampling of the many things that go on that a Chief Justice of North Dakota described the job to me as half legal, half administrative, and half PR. And we all chuckled and said, well, that doesn't add up. That's 150%. But he was making the point that you spend a lot of your time doing that your colleagues on the court are not. Those are unique to the Chief Justice.
Yes, I know it's a tremendous duty and responsibility. And lots of things come up, and that's the next topic I want to get into.
Okay.
During your 17 plus years on the court, as always, before and after your tenure, the court receives a lot of very difficult cases, and they have to make the final decision on those cases, and the public doesn't always understand, and the legislature doesn't always understand, and there are some difficulties involved, but there was a particular period of time when, I know you recall this, when the cases of the school finance and how much money for the legislature should appropriate to the schools, the public schools, in order to satisfy the requirement of the Kansas Constitution. And that came before the court on numerous occasions. And it was quite a period of time, and you were Chief Justice during that time. Can you, this will probably be a more lengthy discussion, but it's very important because it was a confrontation, really, of what role the judiciary plays and how independent it can and should be. So I'll let you move forward on that.
Very well. And if I, please feel free to interrupt, or when I pause to take a breath and say, well, what about this? What about that?
Okay.
Because trying to distill 4 or 5 years into one little monologue here
Exactly.
is very challenging. I might say that around 2002 and 3 and 4, the Supreme Court was handling one school finance case. The plaintiff was called Montoy. And ultimately, after hearing the case 3 or 4 times, in, I think, 2006, the Supreme Court said, okay, legislature, you have substantially complied with our prior orders. You are in substantial compliance with the mandate from our Constitution to provide suitable funding for public schools K through 12. And basically, Montoy was dismissed. And then around 2010, as I said earlier, there was a nationwide recession, and the legislature not only required me to close courts, but they also cut funding for the schools. And there was some residual hard feelings from certain legislators because of Montoy. They didn't like what the Supreme Court had ordered. So in 2010, once some of the people who thought that because of these education funding cuts were resulting in inadequate and inequitable education, they filed a lawsuit against the state of Kansas once again. So that just kind of raised the hackles of some of the legislators who had remembered it from 2006 in Montoy. And I became Chief Justice, as you said, operating essentially as Chief Justice starting in January of 2010. So I was either operating as or the actual chief when that lawsuit was filed. It was called Gannon v. State. And we heard that case 7 different times over about a 4 or 5 year period. The final decision was reached in 2019. So about that time, that November 2010, Sam Brownback, a conservative Republican, was elected governor of the state. In January 2011, he took office, and I asked for and was granted the opportunity to give my State of the Judiciary speech to the assembled chambers of the legislature. You may know that 40 senators and 125 representatives all assemble in the House chamber. The Chief Justice comes into the chamber and makes about a 20-minute speech talking about the state of the Kansas judiciary. The same thing is done for the governor. The governor comes in every January and gives a State of the State speech. The same audience and other dignitaries are in the audience. And then in 2012, I again went to the legislature and was given the opportunity to give my speech on the state of the judiciary. And that is the year when this Gannon case made its way to the Kansas Supreme Court for argument. So it was pending for some time. In November of 2012, I think at least 8, maybe more, moderate Republican senators were defeated in their bid to be reelected. And I will say, according to the news media, Governor Brownback had a hand in their defeats. He wanted them out and wanted them replaced by
They
more
were being
conservative.
challenged by other Republicans
Yes.
who were more conservative.
Yes, they would lose in the primaries, most of them, and they were replaced by more conservative Republicans. And what's interesting is the then Senate President, Steve Morris, who had been in the Senate, I think, maybe 20 years, he was defeated by a more conservative person out by in Stevens County, that area where he's from. And at about that same time, the Speaker of the House, Mike O'Neill, chose not to run for re-election. And so in December, that meant that both chambers had new leadership. A very conservative Republican named Ray Merrick became the Speaker of the House, and a very conservative Republican named Susan Wagle became the President of the Senate. And of course what that meant was that conservatives now controlled both chambers in the legislature, and conservative Republican Sam Brownback was the governor. So the other two branches of government were now being led by very conservative folks. And I apologize for having to refer to a couple notes here because it gets a little complicated,
Fine.
and my memory is not as good as it
No, I
used to
think your
be.
memory's great.
Okay. About that time, some proposals surfaced to change the way that Supreme Court justices were selected. I mentioned earlier the nominating commission. That had been our system since the 1958 amendment to our Constitution. And it, in fact, replaced the prior method, which was statewide elections. If you wanted to be a justice on the Supreme Court, you just said, I want to run, and it was like running for governor, running for attorney general, running for secretary of state, et cetera. And there was an issue that arose in the late 50s that a lot of voters didn't like. I won't go into the details, called the triple play. And so the Constitution was amended. So we changed to this, what's called the merit selection. So we no longer elect, but that possibility is being raised again. Let's go back to electing them. And if we don't do that, let's do the federal model, which, as you know, the governor, like the president of the United States, says, I'm going to pick this person to be on the Kansas Supreme Court. And then if they get confirmed by the Senate, then they're in. And then the other people in the state who says, well, wait a minute, I want to be on the Supreme Court. I want a chance at that. That's just lost. For example, in 2002, when I applied for the Supreme Court, there were a total of 18 people who applied. There were 4 Court of Appeals judges, there were 6 district court judges, and there were 8 lawyers. And it was come one, come all, we like competition. Let's see who the best candidates are. And that was a system that some legislators and the governor wanted replaced. In 2013, in January, I asked then Speaker of the House, Ray Merrick, for the opportunity to come over once again, give my 3rd State of the Judiciary speech in a row, and he refused. He basically said, we're too busy to listen to your 20-minute speech. Just send your report over in writing.
And I will interject here. There's not a statute that requires that you give a presentation before that branch, but it was very traditional. I think Chief Justice McFarland often did not, and she submitted it in writing. But it was more often the case, as you described earlier, that the chief would enter the chambers or enter the House of Representatives with the other justices to give that presentation to that assembled body, so all the legislators from both the House and Senate would hear it in person. So
right. And I just thought, this is the one chance per year that I have to speak directly to our elected representatives.
yes.
And they get a chance to see me, they get a chance to see my colleagues. I invited the Court of Appeals judges to go sit in. They were all in their robes. And I just thought, here's my chance to explain what we're doing and why we are asking for a few things. But as I said, Speaker Merrick said, no, not going to do that. That was, as I understand it, seconded by Senate President Wagle. She said, yeah, we're too busy. Submit it in writing. One of the papers in Kansas called it a, quote, rude snub, unquote, of the Chief Justice. And it's interesting, a week or so later, President Wagle said, well, we're waiting on that school of finance decision in Gannon. And once the court releases that decision, and I want to quote here if I may, she says, what we're going to do is focus on what is the role of the Supreme Court. Should they be interpreting the law, unquote. Well, that's what courts do. That's a core function of the courts, and they've been doing it for hundreds of years. So for the Senate president to say, well, when that decision comes down, we're going to have to see if the Supreme Court really should be interpreting the law. I wasn't quite sure what she had in mind, but it didn't sound like it was consistent with the Kansas Constitution and what judges typically do. And even though Speaker Merrick had refused me the chance to come give my State of the Judiciary speech, he invited Governor Brownback over to give his State of the State speech that same time in January of 2013. And in his speech, Governor Brownback said, you know, it's important that we change this way of selecting Supreme Court justices. We need to either elect them or we need to have the federal model. And the 7 justices were sitting there hearing him say this, and we thought, okay, what does this portend? You know, what's going to happen? So we were kind of keeping our eyes open. And in fact, later that year, there was a very influential state senator who approached the judges in the Kansas District Judges Association. It's a group of about 150, 160 judges. And he said, you know what? If you will support changing the way that we choose Supreme Court justices like Governor Brownback wants, then given my influence, I will urge the Senate to pass a bill giving long overdue pay raises to all your employees, 1,500 to 1,600 of them, long overdue. And this association of judges says, no, we're not going to do that. So in the meantime, we still had the Gannon decision pending. Our court has heard the oral arguments, and we're thinking, how do we want it to come out based on the law? What are the requirements? And then have the opinion written. So that takes us through 2013.
Okay.
Ready to move on?
Yeah,
2014.
Keep
Okay.
going. It gets more exciting.
It gets more exciting. In January of 2014, I told the legislature that unless the judicial branch got about $8 million more in funding, we were going to have to close the courts after July 1 when the new fiscal year started. And I reminded them, because we didn't have funding in 2010, I had to close the courts for 4 days. So this is not a threat. I'm not bluffing. This is a reality. And I also had to close the courts for 1 day in 2012. So I said, you know, believe me when I tell you this. Well, perhaps in response to that, the legislature created what was known as House Bill 2338. And it provided $8 million in funding. But it also provided that the district court judges in a judicial district would now choose their own chief judge in that district, and that chief judge would then be responsible for operating and supervising their own budget. And this was directly contrary to how things have been done for about 40 years in Kansas. There was a constitutional amendment in 1972 passed by, I think, about 60% of those people who voted statewide. And they said, we want to unify the Kansas court system because it was kind of disjointed at times. And we want to give the Supreme Court the general administrative authority over all the courts. So this same influential senator who had been trying to persuade the Kansas District Judges Association in 2013 approached them again. And he said, in exchange for your support of this bill, with this local chief judge selection and the budget control, I will urge that the Senate pass this bill So you can get $8 million and keep our courts open. And he, according to my information, he said, there is no other measure in the legislature to provide you the $8 million other than this one. So if you don't agree to this, then the courts will have to close. So they reluctantly said, all right, we'll support it. And within hours, the Senate passed this House Bill 2338. On March 7th, right about the same time, we released our decision in Gannon, and I'll call it Gannon 1. This was March of 2014. And we held that the legislature had violated the Constitution because the public education funding, K through 12, was inequitable. And we sent it back to a 3-judge panel for the panel to determine if it was also inadequate. Okay. And about that time, I sent a letter to some legislative leaders, primarily on the judiciary committees, and I said, in looking at this proposed bill, House Bill 2338, please keep in mind what the Kansas Constitution actually says. And I said, it's Article 3, Section 1. It grants, quote, the Supreme Court general administrative authority over all courts in the state, unquote. And then I went further and I did an op-ed piece on March 17th that was published in a lot of state newspapers, and it was titled, "Do you like where this road could lead?" unquote. And I asked, if Kansans start down the road where judges feel compelled to bargain away the court's authority, where does that road end? Unquote. Well, despite my letters to legislative leaders and my op-ed piece, the House passed HB 2338. Governor Brownback signed it, and a major Kansas newspaper called this, quote, political payback, unquote, for the Gannon decision and some other decisions that we had rendered on death penalty, etc. In addition to that, there was another bill that became law. It was House Bill 2446, in which the legislature said, all right, courts in Kansas now will have deadlines that we are imposing on you. You have to get your decisions made and released by these deadlines. And if you don't, then the attorneys are authorized to contact you and see what the problem is and take it from there.
And that was directly pointed at the Supreme Court, is that right?
Yes,
Okay.
Primarily the Supreme Court. And so that's kind of how things ended in 2014. In January of 2015, once again, Governor Brownback gave his state speech to the legislature. And once again, for the third year in a row, he called for changing Supreme Court selection methods. So I did another op-ed piece for the newspaper saying we should keep our retention system, our selection system. And I even quoted the Texas Supreme Court Chief Justice, who was a product of electing justices. He had retired, and he wrote an op-ed for the Dallas Morning News, and he said, no, electing justices on the Supreme Court is not a good way to go. What you need to do is do what about 22 other states do, including Kansas, and that is the merit selection system, the nominating commission, et cetera, et cetera. And I said, what more evidence do you want? The Texas Chief Justice, who's a product of that system, doesn't like it. He likes the Kansas system. Well, that same month, one of our chief judges, Larry Solomon, filed a lawsuit, and he was arguing that this House bill, HB 2338, was unconstitutional because the provision that said local judges, you get to pick your own chief judge, violated the Constitution's separation of powers doctrine. In other words, the legislature cannot take away the judiciary's power that's been granted to them directly by the people in that 1972 constitutional amendment. Well, it gets real interesting now because shortly after he filed his lawsuit, the legislature passed House Bill, or HB 2005. The good news is that it provided 2 years of funding for the judicial branch, about $270 million in total. But it had what they call a non-severability provision. And it said, if any part of this bill is found to be unconstitutional, then the entire bill fails. And it said not only, so you're losing the $270 million, but it also said that last year's bill, HB 2338, will also be subject to that. If any part of it is found unconstitutional, then you lose that funding. So what happened is, as an example, if a judge says the chief judge provision in House Bill 2338 is found unconstitutional, then the judicial branch loses $278 million. Well, that was quite a surprise to us. And a major newspaper at that time wrote, and I'll quote, "You can't threaten to shut down the judiciary if courts don't rule the way you like. That's what we expect from a third world dictator," unquote. So, what had happened in the prior year, 2338, also had a non-severability provision, but it only applied to that bill. So if the chief judge provision was declared unconstitutional, you lost that $8 million. But with this bill in 2005, they put the whole thing together. And it's not just a loss of $8 million, but $278 million. Okay. Well, while Judge Solomon's lawsuit is pending, the Supreme Court issued an order after appropriate briefing, and we said this House Bill 2446, in which you're requiring the Supreme Court to file its opinions by your imposed deadlines, that's unconstitutional. That is not within your purview as a legislature to tell the judicial branch what to do. And it was an order I signed, and I cited a number of cases from around the country, and I'd say almost all of them said, when that issue came before them, this is a judicial branch function, you need to stay out of it. Okay, so whether that further inflames some things, I don't know.
Well, I also know that at that time, courts throughout the country and legislatures throughout the country, they were really focused on Kansas and where this was going. It was not an isolated thing, it was a nationwide focus.
It was, and to pick up on that point, Richard, as I said, when I went to our annual Conference of Chief Justices meetings, I had fellow Chief Justices from around the country saying, "Lawton, I just heard X, Y, and Z is going on in Kansas. That can't be right." And I'd say, "Yes, it is." And the president of the Conference of Chief Justices, the president of the National Center for State Courts had talked to me in 2013, and she said, "You know what? I'm going to set up some of your fellow Chief Justices to visit with you when you come to conference. They've been through some battles with legislatures and governors in the past. You can use their experience." Okay. So I met with 3 or 4 of them. The Chief Judge of the New York Court of Appeals, which is their highest court, a former Chief Justice of Oregon, and then the new Chief Justice of Oregon. And there was one other chief, I can't remember. And they would explain to me what had happened in their states and how they handled it, and I explained what was going on in Kansas, and they basically said, "Good luck, we don't have any answers for you. We never faced anything like that." And as I said, other chiefs would come up and say, "I just heard such and such. That can't be right." And I said, "Yes, it is." But the good side is the Chief Justice of one of our largest states approached me at a conference, and she said, "I really want to thank you for standing up for our judicial system and the rule of law, because if you don't stop it in Kansas, it's going to spread to my state and other states." And I had people from southern states, from East Coast, from West Coast, from the northern states. I'd say about 5 or 6 chiefs altogether basically said that same thing. They were really keeping their eye on Kansas. And as a consequence, I was invited by the American Bar Association to come speak to them in 2014 in Boston about this experience. I later was invited by the American Bar Association to go to San Francisco in 2019 to talk about what had gone on in Kansas on a panel of judges. I won't go into the details, but a lot of people were watching what was going on in Kansas on this very issue, and so they were very happy that we were standing strong. And I say we, I don't want to take all the credit. I'll take credit where credit may be due, but a lot of people supported us in that endeavor. Certainly all of my colleagues, many of the judges around the state, lots of employees, et cetera. So that was a good thing.
So where did Gannon end up?
Gannon went back and forth 7 times, and I was going to say, if I could go back to an earlier point,
Sure.
I'll come back and pick up Gannon. I left off by saying that we had released this order saying, legislature, you cannot tell us under the Constitution when we have to release our decisions. Okay, that was in July. Then in December, we released the Chief Judge Solomon case, in which we said, Chief Judge Solomon is right. Legislature, you cannot do what you did. You don't have the authority to tell us we no longer get to choose the chief judge, and that the local judges get to do that. And as a result, that law was null and void. And of course, what that means is it's as though the law never happened. And when it's void, since it carried that $8 million from 2338 and the $270 million from 2005, there was now $278 million potentially being lost for the Kansas judicial branch. That's a very serious matter because that was our entire budget for 2 years. And I had written a little note to myself here, if I may read it. In effect, the Solomon case answered the question, should the judicial branch have to give away some of its power granted directly by the people and their Constitution in order to get funding from the legislature? Funding that courts need for staying open so they can provide justice to the people of Kansas. And I think Solomon said, yeah, you're not allowed to do this. Okay, well, where does that leave us, Richard? We now have a decision that says this provision is unconstitutional. It was in a bill that had a non-severability provision in it, so that means that $8 million is gone. And because of the later statute that was passed and signed into law for $270 million, was also dependent on the constitutionality of choose your own chief judge. There's now no funding for the Kansas judicial branch. So giving credit to the legislature, within a few weeks, when they first came back to Topeka, they fixed the problem. They said, we're going to take out the non-severability provisions. We're going to put in severability. So if something in that law is declared unconstitutional, the funding is still there. So that was quite an experience when you're looking at how do we keep our courts open to provide justice to Kansans? How do we pay our employees? You'll have to send them home because there's no money. The judges you have to send home because you can't pay them either. So there's just nothing for the judicial branch to do. This is one of the 3 branches of government that's just been told, you know, you're not going to do anything. So it's not surprising that this, as you pointed out, reached some national attention in particular. And the New Yorker magazine, shortly after the legislature acted, wrote an article. It was called The Political War Against the Kansas Supreme Court. And it concluded that these specific bills that we were just talking about had been passed in response to Gannon 1. In other words, to punish the Kansas Supreme Court. And it also said now that there's been a legislative fix, quote, the legislature blinked, unquote. And I happen to bring that article with me. I framed it, I kept it in my chambers when I was Chief Justice, and people are free to read it on their own, but I've concluded basically what it stands for.
What was the date of that article?
This article is February 5, 2016.
Okay.
So it's about a week or so after the legislature fixed the funding problem. So,
I just want to interject something here and keep your train of thought.
sure.
But we're talking about all this is going on with this particular issue, which was very difficult. And I mean, the state was just embroiled. But you also, and the court, you also were doing the work that you were supposed to do. You were
Right.
still hearing other cases. You were still writing opinions. So your work didn't stop there, but this was that add-on difficulty that you had to persevere through.
It was add-on, and I mentioned this sort of action required me to draft op-ed pieces and put them in the newspapers and say, you know, I like our selection system for for Supreme Court justices, and I please look at the Kansas Constitution, and when it says the Supreme Court has general administrative authority over all courts, and now the legislature is basically saying we no longer have the authority to choose the chief judges for the 31 judicial districts. We no longer have the ability to control the budget, because the legislature in one statute says, I submit one budget for the entire judicial branch. But now they're saying each individual chief judge in the 31 districts has that control. And the Supreme Court had a number of conferences in which we were discussing, well, okay, what's our worst case scenario? If we don't get funding, what are we going to do? Do we close all the courts, or do we try to keep a court or two open for some reason, as we had done in 2010 and 2012, or are we just completely out of luck? And I think we concluded we're just out of luck. There is no money, none available, and you cannot ask people to come to work and not pay them. That violates the Fair Labor Standards Act. So there were just a host of interconnected issues there. You know.
Well, luckily it got funded.
Luckily it got funded. And in the midst of all this, about a week after this article from the New Yorker, we released our Gannon 2 decision. That was February of 2016, and we held that the state had still failed to cure the inequities that we had identified 2 years earlier in the Gannon 1 decision in March of 2014. And we gave the legislature until June 30 to fix the problems. And we noted that if your public education funding system is declared unconstitutional, that in effect says it is null and void, and it is as though it never existed. So if you don't have a funding system, how are you going to operate the schools? You can't appropriate money for them. You can't distribute the money to them. They can't spend that money because your whole system,
There is no
there is no system. And we relied upon some decisions from other states. I think Arkansas was one of them, when you said you can't operate under something that's unconstitutional. It just doesn't exist.
And you kept jurisdiction of that case.
We kept jurisdiction. And
Which means what?
Keeping jurisdiction means that we sent our decision out to the world, and in particular the legislature, and said, here are the problems. You've solved some of them, but not all of them, and you need to fix these. And we're giving you till June 30 to do that. And as I said, we retained jurisdiction, so we basically were saying, this case is not dismissed, and we're going to have to see some action from you by June 30 to fix these problems. If not, we'll have to do something else. And so this went back and forth until 2019. As I said, we had 7 different decisions involving Gannon, and sometimes they would fix the inequitable problems, but leave the inadequacy of funding problems alone, or they were not completely adequate, and sometimes it was a mixture. And they came up with a number of different solutions, but it was not until 2019 that we said, okay, you've completed this. And That's where we are on Gannon. So you take Gannon, 7 decisions, and Montoy, the other school of finance case, I think we had 3 or 4 decisions there. The Supreme Court during my tenure spent a lot of time on school of finance.
Yes.
You know,
And that is, I mean, that's a very unusual situation, but it's not unprecedented to have a case come back a number of times before a final resolution seems to take place. New issues come up
right.
with
Right.
every decision.
If I may, Richard, I wanted to follow up with that New Yorker magazine article. We
Sure.
were talking about that effort. The New York Times also got involved about a month or 6 weeks after we released our Gannon 2 decision. This is that article. It's dated April 2nd, 2016. I don't know if you can see that or not. You might get some glare off of the camera. But this was a front page article on the New York Times. And it says, outraged by Kansas justices' rulings, Republicans seek to reshape the court. And as I had mentioned, this first article, the New Yorker, called it the political war against the Kansas Supreme Court. And then kind of a variation on that theme was the New York Times, emphasizing that Republicans are trying to reshape the court. And the article goes on to talk about all the outrage, as they described it, by Governor Brownback and conservative legislators over Gannon decisions, some death penalty decisions we had reached, and some abortion-related decisions. And as a result, Governor Brownback and these legislators had reacted with a renewed desire to change the way Supreme Court justices are selected. And I think it's important that the Times also observe, quote, the legislature threatened to suspend all funding for the courts, unquote. So they were quite aware of what had been going on with these bills. And that emphasizes what you and I talked about a few minutes ago. There are a lot of eyes nationally watching what was going on in Kansas. So I didn't mean to interrupt. You were, I think, going to guide us in another direction, but that kind of takes care of the chronology of events. And as I say, I apologize for having to write some of this out, but there was a lot going on, and it was important to get the timing of these events right instead of my trying to go off my memory.
Well, sure. Thank you for that
Thank you.
discussion, and it's just important. I think a lot of people, the public, learned a lot, maybe about the Constitution and what it says and what the court authority the court has. A reminder that when they passed the constitutional amendment, that's the authority they gave the court, and the judiciary did not back down, and maybe the legislature learned from that also. It's a difficult time. Things like that happen, and they're happening today, and there's a lot of, pushback, but with our system, we have ways that can deal with that. It just takes time and energy and a lot of sleepless nights. So
A lot of sleepless
a lot
nights.
of editorials.
a lot of editorials. And one thing I would emphasize is, and you were pointing this out, our founders federally in the 1780s came up with 3 branches of government. The Kansas Constitutional Convention in 1859 did the same thing. We've had 3 branches in Kansas ever since. And yes, sometimes there is tension among the 3. Sometimes, as in Kansas, there was tension, 2 of them on one side and the judicial branch on the other. But as far as the judicial branch is concerned, and I speak only for it, we believe in the Constitution and the rule of law, and as you well know, we don't make decisions because they're politically popular. We make some that are politically unpopular. But that's not our function, is to do what the people want on a daily basis. We follow what the people want in their Constitution. And then when they change the Constitution, that binds us as well. And that was one of the reasons why I kept my oath of office framed on the wall of my chambers. It was above my light switch. So every morning when I came in, when I turned on the light, I could see my oath, be reminded that I swore an oath to support the Constitution of the United States and the state of Kansas. And I would be reminded of that when I left at night when I turned the light off. And we make decisions frequently that are not politically popular or that we don't want to make. And privately we say, gosh, as an individual, I don't like having to do this, but this is what the law requires. And you have run across some of those, I think, in your work, to take a defendant who was convicted of committing sex crimes against a minor, and then we determined that the defendant did not get a fair trial, and now we reluctantly have to send it back. We reverse that conviction, remand it to the trial court to see if they want to do this over, if the prosecutor wants to continue prosecuting. And we know very well we're putting that child victim through an ordeal of having to testify again. We're putting his or her family through an ordeal, the community through an ordeal. But that's what the law requires, and everybody's entitled to a fair trial, and including the people who are guilty. They're entitled to a fair trial. So that's what we try to keep in mind when we have been doing the work up here.
And probably the most difficult thing for the public to understand is that you are doing the work and following the Constitution no matter where it leads. And I remember once with the car murder cases, horrible crime in Wichita, and a very difficult case for the court. I think there were 40-some issues brought before the court in that case, and your ruling on the case where you upheld the convictions, but you reversed on the punishment. Again, following the Constitution in what you believed it said, and the outrage by people that you never released these two murderers.
Right.
But it was just an outrage by people that didn't understand the difficulty of what a judge has to do to make things right. And that's when I didn't write an editorial, but I wrote a letter to the editor. I had retired, so I felt I could do that. But I pointed that out. I said, in all my time with the court, I knew how anguished you were to have to make some of those decisions, because morally you sided with the people and the reaction, but legally you had to rule the way you did, because that's how the law operates. So I think that's a really good point that you made, a significant point for people to remember how, not that it's difficult to be a judge, but that's how you have to rule, following the law, following the Constitution, not following the politics.
Exactly. And in that particular case, as you were mentioning, we decided that having both defendants in the same sentencing hearing, when basically at times they were pointing the finger against each other, that was not the proper way to handle a sentencing hearing. They should have a new sentencing hearing, one separate for each of them, so that finger pointing did not occur. And so the convictions for all these crimes were affirmed. And it's not that we didn't believe in the death penalty. It was that they needed to have a new sentencing, and that apparently has now occurred.
And if each got sentenced to that, that
Right.
was fine. You were just trying to split them apart.
Right.
The U.S.
Right.
Supreme Court did reverse. I think it was 5-4 decision, wasn't it, on that case?
They did reverse, and they basically said having this done the way it was done at the trial level did not make any difference, because the evidence was so overwhelming of their guilt, and that carried over into the sentencing hearing.
Yeah.
Basically, Justice Scalia said, as I recall, it made no difference having this sentencing, because the people doing the sentencing, whether they were separate or whether they were together, every person who ever looked at this as a sentencing
really
entity would say, you're getting the death penalty.
Yeah.
Yeah.
but it was 5-4, so it wasn't.
I don't remember what the
Okay,
holding was.
okay.
Yeah.
Okay, we're about towards the end of our interview. I'd like to switch off of all of the prior discussion there and just ask you some personal questions. In your 17 plus years on the bench, what are some things or one thing that you are most proud of?
Well, I touched on it a few minutes ago, and that is during this time that we went through this narrative, I was so proud of how the people in the judicial branch stuck together. I know, and that question has been posed to me over the years, usually by news reporters, they think I'm going to tell them what I'm proudest of. Well, it's an opinion I wrote for the court, or I wrote a dissent on a death penalty decision in Marsh for the court around 2004, 2005. I was in the dissent. I said our death penalty is constitutional. It went to the U.S. Supreme Court, and they basically, without mentioning my name, said, yeah, we agree with that analysis. It is constitutional, citing the same cases that I had cited. But I say I'm proudest of how we just stuck together. The people in this building, other judges throughout the state, other employees throughout the state. It would have been so easy to have said, oh, this is too hard, or we don't like this, we're going to go someplace else. But we did our best to abide by what the Constitution requires, the rule of law, and our employees understood that, as did the judges. So a judge years ago, when I was chief, said, a good strategy for the other branches of government against the judicial branch is to divide and conquer. They want to cut you into little pieces and divide and then conquer each piece individually until you've lost. And so I say that didn't happen with the judicial branch, especially when I was Chief Justice. We stuck together. We had some individual differences of opinion, the justices, but we stuck together on the big issues.
Very good. Is there anything you regret? Not decision-wise, but I mean opinion-wise, but any regrets of something you would have done differently? Is that a fair question?
I can't think of any right offhand. Perhaps when I'm driving away from this interview later, I'll think of something.
No.
But
did you like your service?
I did. I really liked my service. When I was sworn in on October 17th, 2002, I quoted one of my favorite baseball players, Lou Gehrig, who had famously said that he considered himself the luckiest man on the face of the earth. And I said, that's me today. I just can't believe I'm here. I never planned on applying for the Supreme Court, but I was, I don't want to say urged, but I was requested to by these judges in Salina. I was very lucky throughout this process, and that carried through with me every day. Now, I acknowledge that not every day was perfect, and there were some days I would say, oh my gosh, I've got to go do this today, or I've got to do these other tasks. But I always stopped and looked at the oath of office on my chamber's wall, and I would say, how many people in the state of Kansas would give a lot of money to be in your shoes? Because there's only one Chief Justice of the Supreme Court of Kansas, and there are only 56 Chief Justices in the state system throughout the country, and that includes the 50 states, Washington, D.C., and our 5 territories. And then there's a Chief Justice on the U.S. Supreme Court. But I think he's the only Chief Justice in the federal system. Everybody else is a Chief Judge. So to look back on where I came from, basically, as a boy in Salina, Kansas, and then to wind up where I was, I just thought fortune was smiling on me, or you know, God is looking out for me, however you want to look at it. I just was so fortunate.
That's wonderful.
Yeah.
What is life like now after retirement? I know you're a busy person. Just a little glimpse of what you're doing.
Well, I had retired with 3 years left on my term on the Supreme Court. So I served 3 of the 6-year term. But I left early because of several reasons. My wife had given up her career when we came to Topeka 17 years earlier. And I thought, she has sacrificed so much for me. I want to spend some time with her. And we decided we would work on some issues together. In the space of 18 months, I lost my only sibling, my sister. I lost my only granddaughter and lost my mother. And I thought, life is awfully short, so do what you want to do. And my wife and I decided that we would work on an issue together, and what that has been is veterans treatment courts. I'm on a board of directors for the Veterans Defense Project in Minneapolis, Minnesota, and I'm the chairman of the Veterans Court Coalition, which includes some people from Florida. And the goal of both organizations is to increase the number of veterans treatment courts across the nation and to enhance those that already are in existence. And right now, we're working with the Navajo Nation in Arizona, have Zoomed with them several times, trying to encourage them to follow through and form one. We have a Zoom with them in August. Their tribal council is going to be on the Zoom. We're working with the Kansas tribal nations as well. I've been in contact with Governor Kelly's Native American liaison about that. And we're also dealing with some other tribal nations. I won't go into that in detail right now, but we're looking at places where they don't have them and perhaps have never heard of them before. And I sent a message out to a lot of different organizations about federal funding that was available to people, but they had to apply. The deadline was last May. And I was astounded at how many organizations didn't know the funding was available. And it goes back to what I was saying about the Supreme Court justice selection process in Kansas. Give people an equal opportunity to do something. Tell them, here is an opportunity. Whether you want to come do that or not, that's your choice, but at least know about it. And so a lot of people, a lot of organizations said, what are you talking about? There's funding available? Yes, there is. Why didn't we know that? Well, I happened to do some digging and found out about it. I worked with Senator Jerry Moran's office about a year or so ago to get started on the federal funding issue. He's been very helpful.
Yeah. That's very good. You continue to make your mark on history and helping people. This concludes our interview. I want to thank you for your service to the state, your service to the nation, and I wish you well, but thank you very much for this interview. It's been a great honor for me to sit here with you and to renew our friendship that we haven't seen each other for a while, so thank you very much.
Well, thank you, Richard. As I said at the outset, it's been my pleasure, and I really appreciate this project's existence, recording for posterity what certain leaders in Kansas have to say about their experiences, and hopefully people who watch this can learn from our mistakes or our experience, if you will. And the main thing for me today was just to preserve for future generations what exactly went on in Kansas for about a 4 or 5 year period between the executive branch and the legislative branch versus the judicial branch. So thank you for that opportunity.
Very good. Thank you.